Um, Hello, welcome to another episode of the Tyrants Den. Today we have a very special guest. Um, I'd say he's probably top five libertarian thinkers, to ever exist. And I'm quite excited for this. Stephan Kinsella, welcome.
Good day.
Yeah, good day. Um, so so you're a patent attorney. So I'm just curious, like, what's it like being an anti-IP patent attorney? Do you file patents or like and do that stuff?
Uh, well, I did. So I'm an attorney. Well, I'm kind of retired attorney. I'm not doing that much work anymore. I'm basically retired. Here in Houston, Texas, I was a practicing patent attorney for a good 30 years, um, starting around 1992 when I started practicing law. And yeah, so most of my career I did patent law or patent law, as you guys call it. And I did in the US, you can either do, if you're a patent specialist, as opposed to other types of IP like trademarks or copyrights. The patent law specialists tend to have technical degrees like me, engineering backgrounds, and you either tend to do litigation or you do what we call patent prosecution, which means you prepare patent applications for clients and you file them with the patent office. And that's mostly what I did. For my clients, I would interview their engineers, their inventors, and understand their invention and file it as a patent. So I did the work of filing U.S. and international patents for corporate clients, usually in electronics or laser technology, optoelectronics, that kinds of thing. So I did that for most of my career, and at the same time, around the time that I passed the patent bar in 1994. I was already a libertarian, but I had never thought much about intellectual property until I started specializing in it as an attorney, and I decided as a libertarian writer to turn my attention to the IP issue myself. And I looked into it for a long time and tried to come up with good arguments for IP, what we call IP or intellectual property, because all the arguments I had heard were not good. So I thought I would come up with my own since I knew something about the area. And I concluded around the time I passed the patent bar that the entire system should be abolished. So the entire time I was practicing IP law, I believed that the system should be abolished. Um, just like if I was a drug attorney or as a defense attorney representing clients accused of drug crimes by the state, as a libertarian, I would want those laws to be abolished. But in the meantime, I would still think my services were necessary to help people being attacked by the state. And so likewise, as an attorney, we have a patent system, and so companies need to have patents to defend themselves or to use them aggressively, which I don't support. And I tried not to do that in my career. I tried not to defend people using their patents aggressively, because I wasn't really a litigator anyway. I didn't really file lawsuits. I helped defend lawsuit. I helped in lawsuit support, but usually or almost always, actually always in my case, it was on the defendant side, defending them against a patent lawsuit. So luckily, I was able to maneuver my career so that I never did anything that distasteful ethically for me. I only obtained patents for companies, and how they use them is up to them. If they use them to sue someone, I didn't help them do that. But I viewed my job as more like providing guns to people, and they could use them for good purposes, like for defending themselves, or they can use them for evil purposes. And how they used it was um, not up to me. Now, I will say that over time, I grew to not like as much the patent law practice, partly because of that. But I did it anyway because it was a good living.
Yeah, yeah. Well, from watching your videos, you do seem like you live in a nice home. So, um, so what initially got you interested in law?
I was an engineer because I like technology, but it wasn't enough for me personally because I was interested in economics and political thinking and all that. So I went to law school. to sort of get that other side of my brain activated, verbal reasoning and analytical thinking, other than mathematical stuff, which is what engineers do. And also, I had the feeling like I would be good at it, and I could make more money at it than as an engineer. And also, I just thought I'd be happier doing it. And I think I was right. I enjoyed being a lawyer, and I like the legal, and it's helped. And so the whole time I was doing law, I also had this side hobby of libertarian theorizing. So I would be writing legal stuff for my job, but also publishing, because that's part of what you do as an attorney to get business and to get your name out there. So I wrote legal things on intellectual property law or international law or oil and gas law, which I did at first. But I also was writing legal philosophy and these things, which no one in my legal life knew much about. My clients didn't know about it. They didn't care. I did think that when I started publishing on IP as a libertarian, like writing against it, I was a little bit more concerned that my partners at my law firm or my clients would find out and they would be upset with me. So I kind of toned it down a little bit. Like I published articles saying, are we really sure that patents are a good idea? But over time, I realized that no one cares. No one cares what your personal political views are. And in fact, the few clients that found out about it and lawyers, they were kind of impressed by it because they assumed that I must know something about IP law if I'm able to write about it from like in a legal theory and political philosophy way. They didn't really care what my conclusions were. It just sort of, it made them believe that I was competent. So it wasn't a problem. In fact, I got some clients a few times in my career. I would go to the Mises Institute in Auburn and give speeches on IP law, or on intellectual property theory, or on other topics, libertarian topics. And on occasion, someone would say, "Hey, you seem like you're a good patent attorney. I know you're against the system, but would you help me get a patent?" They weren't upset by the fact that I was against it. They knew I would do a good job helping them get a patent. So I sort of had these both careers at the same time. In the last 10 or 15 years, I reduced my legal practice down to zero, essentially. And at the same time, I was able to spend more time writing on purely libertarian topics, which is pretty much what I do now full time.
Right. And so watching and from reading your stuff, right, it's really given me like a much deeper insight of law, right? It's like taught me stuff about like common law, Roman law, and natural law. And then like I really like I really had no idea what like common law was like prior to you.
Right.
So like it's just, so do you mind explaining that?
Yeah, and this is another area I was fortunate. So I think I was in a ways fortunate because of my intellectual and writing and libertarian interests. I was a little bit fortunate that I had the engineering background, but then the legal background. But I also went to law school in Louisiana, which is the only state in the U.S. which is a civil law state, not a common law state. All the other 49 states are common law, which Australia is too, and all the other Commonwealth countries, and England as well. So the two major systems in the world today would be, well, if you ignore Islamic law, things like that, but the two major Western private law systems would be the common law, which is the Anglo-American law, England and its commonwealths, and then the US. And then the civil law countries, or we call them sometimes the continental law countries, because most of the European countries on the continent, also Latin America, and Latin America and some other countries too, have what's called civil law. And the civil law is sort of a mostly codified version of law, which is a combination of the ancient Roman law and the European customary law that grew up in the centuries since the Roman law. So the Roman law was about 1,000-year period of law before the common law, and the common law was about 1,000-year period of law after the Roman law. And they're both similar in that they're decentralized legal systems. Decentralized in the sense that a common law system, the law is formed incrementally by the decision of judges hearing a dispute between real people and trying to come up with a fair settlement to the dispute based upon precedent or case law that went before that. So that way the law grows gradually, and over time legal principles develop, and the law develops like that. And something similar happened in the Roman law. You had courts and judges, and they would decide disputes when people came before them, and the law grew that way too. The Roman law was largely lost after the fall of the Roman Empire, but then it was rediscovered centuries later and made a comeback later. And and when it came back, it did have some influence on the common law too. So there's some cross pollination between the two. And so the common law and the Roman law are the two big decentralized systems. And in today's world, the civil law of the continental law is the codified version of the ancient Roman law. So those are the two major systems. The other would be international law, which is the law between nations, and then say canon law or church law of the Catholic Church. And law merchant was the customary law between the merchants in the 14, 15, 1600s, which also influenced the legal systems, the private legal systems of the common law. So anyway, it's interesting to understand all that. And I happen to know a lot about common law and civil law because I went to the only civil law school in the U.S. Well, the only solely civil law school. That's Louisiana State University. And also, then I got my master's in international law in London. So I learned about that, which those also turned out to be very relevant, not only in my career, but also in my libertarian career of writing. So it helped me. I think it helped me in my development and extension of existing libertarian theories.
Yeah, no, I think it's interesting that Louisiana's the only state with civil law, because that's like the French settlers, right? And so
It was
yeah.
a combination of the Spanish and the French law, because the Spanish and the French, Spain and France traded Louisiana back and forth a few times until it was. So the law is actually a hybrid of Spanish and French law. The form is the civil law of France, the Code Napoleon, but the substance is arguably both Spanish and French. In Canada, most of the country is common law, but Quebec is civil law for the same reason, because of its French influence. And even in the UK, Scotland is a civil law country, although it's not codified. It's not a civil code country, but it is, I believe, but it's somewhat of a civil law country. So Wales and Ireland and England are all common law, but Scotland is also an outlier in that regard.
Yeah, it's quite interesting. And then talking about Ireland, prior to them being colonized, they had their own law system, right? Brennan law, I'm pretty sure it's called.
I believe so, Brehon law or something like that. I don't know a lot about it, but I think so. And of course, there have been some studies by Rothbard and David Friedman, and I think Gerard Casey, who's an Irish libertarian philosopher, who's brilliant, in his book Libertarian Anarchy, and then Rothbard's, I think, For a New Liberty, and then also David Friedman's The Machinery of Freedom. They both talk about ancient. So I think mainly two ancient systems of law. I think one is ancient Ireland and one is ancient Iceland, and how they were roughly anarchistic in a lot of ways. But I think those are pretty far afield from the modern private law we have now, which are largely drawn from, as I said, European customary law and the Roman law, and then the English common law.
Right. And then as libertarians, like we tend to focus on like natural law, as like Rothbard put it, right?
Yes.
So how does that intertwine with everything else?
Yeah, that's interesting. So and that's why I mentioned canon law of the Catholic Church, because that had a lot of influence from hold on a second. From natural law thinkers like Thomas Aquinas, and also international law. International law is interesting because, in a way, a lot of libertarians don't like it because of the United Nations and all this. And there was a fear for several decades by the John Birchers and the conservatives and some libertarians of a one world state that the UN would turn into. I think that fear has gone down. It seems pretty clear that the nation states are not going to give up their power, especially the U.S. If anything, the U.S. uses the UN as its implement to control other countries. But international law itself it's largely kind of more libertarian than than the law in most nation states today, because the law of most nation states has been tainted by legislation. So the common law and the civil law, which is based upon the Roman law, are all pretty good legal systems. Their private law is roughly compatible in most ways with what we would say is or libertarian property rights principles. Murder is outlawed, prohibited, theft is prohibited, property rights are secured. There's due process, things like that. International law is more general, and it applies to nation states. So the citizens, in a sense, or the subjects of international law are the 200 states in the world, the 193 states or 96, wherever there are right now. But the principles are general and vague, and because the United Nations has very little power to legislate, the customary and traditional international law that has developed by over the centuries has not been tainted as much by legislation. Whereas in America and in England and in Australia and other countries, the bulk of the law now is special statutes and legislation. So to the extent the common law still applies, it's largely pretty good, but you have all these special statutes that come in and override it quite often. The international law was based upon the idea that every country is sovereign and states can trade with each other and they can make contracts or treaties with each other. There's a Latin term called pacta sunt servanda. Agreements are to be respected. And so I think international law, some of the most famous early philosophers like Pufendorf and Grotius, heavily influenced by natural law thinking. So natural law thinking and the natural law type of reasoning has influenced, of course, the ideas of justice that were referred to by judges in the Roman law and in the especially in the common law. So that's how they all tie together.
The international law stuff's interesting because when they were prosecuting the Nazis and all of that stuff, like the lawyers representing the Nazis were pretty much saying, hey, it wasn't against the law in Germany, right, to do this stuff, right? And so the people prosecuting the Nazis were like, well, we're referring to something like a higher law that has been broken.
Yeah, the Nuremberg trials, there are some aspects of it that you could criticize as a libertarian. For example, you could say that, but it wasn't a crime. Yeah, it wasn't a crime under the positive law of Germany at the time. Just like, if one country goes to war against another, it's not technically a violation of their law. It's just an act of aggression between two countries. And unless there's a treaty between them, it's not clear that that's prohibited. I mean, you can go to, but there's always been a law of war. And that's so there are war crimes. There are things you're not supposed to do. And those were limits on the war-making power of states developed by natural law thinkers trying to limit the damage done to civilians and things like that in war. But the one good outcome, in my view, of the Nuremberg trials was it did recognize that there's a higher law principle, which even if they didn't have a sound libertarian basis for it, it's like they at least intuitively recognized. Now, again, they bent the international law to get the results they wanted. Okay, but no one can deny that most of these guys were abhorrent people, which committed crimes that would be actions that would be crimes under libertarian law. Right? They committed mass murder and genocide and torture. So it's not like an injustice to go after them. So the one good thing about the Nuremberg trials is it established the principle that there's a higher law above the municipal law, we call it, the national law of a state. And that reasoning is sort of implicit, like in the U.S., when you have attorneys go to argue before the Supreme Court, and they argue in terms of, my client should win because the Constitution says this, and the other side says the opposite. But quite often they appeal to intuitive principles of fairness and justice. So they're trying to appeal to the natural sense of justice of the judges to get them to try to interpret the Constitution their way to get the result that they're implicitly claiming is compatible with a higher sense of justice. So everyone sort of implicitly recognizes that there's really a concept and a standard of justice outside of the state, which is a good thing. So it means that you can criticize the law for being unjust, and you can't have a legal positivist or a statist say, well, you can't say that the law is unjust because it is the law, and the law is the only way we have to know what is just and unjust. Once you have this idea that some laws are so immoral, and in fact, that principle is present in the idea that of war crimes. Like, there's some things you shouldn't do even if your commander tells you to do it. Like, you can't just say I was just obeying orders if it's so heinous and abhorrent that you should have known. And that's the other thing too. The laws, all these countries have this idea of ignorance is no excuse of the law, which of course is not a good doctrine, because it means that the government can have a virtually infinite number of laws which no one knows what they are, because there's so many laws, because they're made up by the legislature, and you can be held liable for violating one even though you didn't know it, and even though it's not naturally wrong to do it. It's just what we call malum prohibitum, which means it's just wrong because the government makes it wrong, as opposed to malum in se. And so if you had a libertarian order, which was based only on what some might call natural law, or things that are intuitively wrong or obviously wrong, like theft and murder, then there's nothing wrong with having a rule that says you're guilty even though you claim you didn't know it was wrong, because what we say is knowledge of this is engraved on the human heart. And that's because it's just common sense. Every functioning non-psychopathic adult knows that you shouldn't take other people's things and you shouldn't kill other people. Everyone knows that. You don't have to be on notice of that for it to be fair to subject you to punishment. The nature of your actions means it's fair to subject you to punishment. But when you have laws that are artificially created by legislatures, then I think it should be a defense. Like, you're trying to punish me for committing this crime, but you don't even have to show that I had a guilty conscience or scienter, because which you should have to prove, because I think innocence lack of knowledge of the law should be a defense in those cases, but it's not. But the point is, when you recognize that there's a higher law, it sort of supports the idea that there is a sense, there are some things that you just know in your heart are wrong to do. So it makes a distinction between malum prohibitum and malum in se laws.
And I think this might go nicely into like your theory of rights, the estoppel principle. Do you mind explaining that?
Yeah, I mean, when I'd say there are two major strands of ways libertarians and some classical liberals think about rights and just laws. Some are more natural law type thinkers, and some are more utilitarian or consequentialist. The Ayn Rand or objectivist or Randian influence types, like me, don't necessarily think that there's an incompatibility or a contradiction between those two. And I don't think it's just a happy coincidence. I think that Rand was right that the moral is the practical. And so if you have a justified moral principle, it's also going to be practically the best one. I mean, property rights, as Rothbard says, all rights are property rights. All human rights are property rights. Well, all rights are individual rights, and they're individual rights of humans. And all these human rights, they're property rights. That's just what rights are. They're property rights. They're rights to control a scarce resource, including the resource of your body, because that's what it means to say that aggression is not permitted. Because aggression means using someone else's resource, their property, without their permission. That's what aggression just means. So, so property rights are. Sorry, I just got a text that distracted me. What was I saying?
Property rights, and I asked about estoppel and.
Oh, right. Yeah. So the two main types of thinking. So the utilitarian or consequentialist says that we should have the type of the laws that lead to good consequences or results. And then the sort of deontological or natural rights guy says that, well, by man's nature, we can deduce how we ought to live and how to act, and therefore, by man's nature, we can come to conclusions about what's right and wrong, what's naturally right and wrong, and what natural laws are, well, therefore, what natural rights are. And that was always sort of the thinking of judges for 2,000 years. It just wasn't that systematic, and it wasn't always that consistent. I view libertarianism and libertarians as just people that are much more consistent about applying all this, and then looking for the common principles and boiling it down and simplifying it, getting rid of errors and getting rid of inconsistencies. So I was attracted to the natural law thinking of Ayn Rand because she basically said that, it's just not common sense, but it's intuitively obvious that the only way you can violate someone's rights is by using force against them. And so therefore, the only time you have the right to use force without someone's permission is in self-defense. There's a reciprocity there, but you never have the right to initiate force. Now, her argument was a little bit natural law oriented in the sense of she thought our nature determines what our rights are. But the problem with that, according to some like David Hume and people who follow him, is that you have a logical gap there going from an is statement about the way things are, the facts of the matter, to an ought statement, which is a prescription about what you should or should not do. And when I was in law school, I always like, I don't think it's a major problem, by the way. I think that common sense, decent values, the common values most people have tend to be pro peace and pro prosperity and, empathetic towards each other. So people believe that anyway. Yeah, go ahead.
Well, according to some people online, common sense values are having a welfare state and universal healthcare and all of that stuff.
Yeah, well, they're inconsistent, but I mean, most people would admit that it's wrong to hit people. They just also favor hitting people when you need to take their money. So they're inconsistent. But the point is, most people intuitively recognize that we should have laws against murder and theft. When I read, so Hans Hermann Hoppe, who became Rothbard's sort of a partner and student and protege from 1985 to 1995, when Rothbard died, he moved to the U.S. and lived with not lived with, but taught with and partnered with Rothbard. He was an up and coming libertarian thinker, an Austrian economist and philosopher, and he came up with the argumentation ethics idea, which is the idea that the way to sidestep this is-ought gap and to come up with a different form of natural rights thinking is to say that basically any form of socialism, by which he meant an ethic, a political ethic, or a set of laws that is based upon the idea that you don't respect people's property rights, the way to defend that is to recognize that the only type of system that could be justified is by an argumentation. But argumentation has certain normative presuppositions because it's not just a factual matter. You have to respect each other's body rights when you're arguing with someone or discussing things with someone. So there's like an implicit recognition of the importance of these values. So you could never argue during such a discussion for a system that obliterates those values. So it was sort of a way of showing by contradiction that you would have a practical contradiction if you argued for socialism, in effect. And when I read that, I thought it was great. But I also, at the same time, was in contracts law class in law school, and I had just learned about the common law concept of estoppel, which is a legal doctrine, which is a way of getting around some formalities in contract law, which would prevent someone from collecting on a contract, like suing for breach of contract, if there had not been some formalities, like you forgot to pay consideration, or there was no offer and acceptance. So the judges would say, well, there would be an injustice done if we let this guy get off the hook here. So we're going to come up with an equitable remedy here. And they called it estoppel, which says that if you acted in a way previously that contradicts your claims now, you can be prevented or stopped from making that argument in the interest of justice. That was sort of just a legal doctrine, which was used also in the Roman law to a certain degree. And I recognize that the insight behind that doctrine or the intuition behind it was similar to the logic of libertarian rights, because libertarian rights says that you can only use force against someone in response to force. So there's a symmetry there. So I recognize that the same thing would apply. The reason why you're entitled to use force against an aggressor, but he's not entitled to use force against you, is that you can object to his using force against you because you haven't done anything to him. But if you use force in response to retaliate against him or to use force to defend yourself against him, he can't object to it because he would be stopped from complaining about it effectively by the fact of his previous actions. So I turned that idea and I used it, I integrated it with Hoppe's idea, and I came up with my own theory of rights. And that was one of the first things I wrote in 1992 in Reason Papers, Tibor Machan's journal. So that was originally my interest always was rights theory, but then how it applied, like for contracts and causation, and then intellectual property later. Most people know me from IP because that was most people have heard about that. But my interest was never IP only. It was always it was a host of other issues that are related to it.
Yeah. So a story that I find somewhat amusing and somewhat horrifying is that I think it's Melbourne, right? And this guy broke into this other guy's house, right? But then the victim overpowered the person and just kept him as like a sex slave for a couple of days.
Yeah.
Right. And I'm just thinking, because you said like before that like that it pretty much so this person can't argue for their rights in to some extent, but I feel like that's way too far.
Right. And so the way I work mine and the way Hoppe works his and the way the legal system works is there's a proportionality requirement. And the reason is because, so in my argument for rights, proportionality enters into it because you're only stopped to the extent of what you did. Okay. So if you commit a very minor thing, then you can't really make the argument that I don't believe in aggression at all because you committed aggression. But you could tailor your claim to the facts of the case. You could say, well, I slapped you in the face. So I kind of admitted that slapping someone in the face without their permission is something that people have the right to do. So I can't really complain about being slapped back in the face. Something like that. It could be maybe more, but something on the same type or level. But if it's beyond that, if the victim wants to murder me or to execute me for it, I could say, no, that would be killing me without my permission. And I have the right to complain about that. I'm not stopped because I only did so much. So a proportionality would enter into it. Now, in the case you mentioned, I don't know the particulars. So there's two problems with what the guy did. Number one, he might have overpunished. I don't know. I mean, you could imagine a case where he didn't overpunish, where the guy broke in, he raped the guy's daughters and this kind of stuff, or murdered his kids. And then you could say that, keeping him as a sex slave for a year, like literally was proportional punishment. You could say that. I'm assuming this was disproportionate punishment. So that's one problem with it. The other problem was, even if it's proportionate punishment, the other problem is taking the law into your own hands is always a potentially problematic thing. This is why the common law systems, and I assume the civil law systems, I'm not too sure, but I know the common law systems like in the US and in England and the Commonwealth countries, there's always a right to defend yourself. You don't, like, if someone breaks into your house, you can defend yourself. You don't have to wait for the police to show up. So in those cases, you can take law into your own hands because there's just no choice. So in those cases, you can be judge, jury, and executioner, right? But you're still supposed to act reasonably, right? So once you subdue the guy, for example, let's say you capture the guy and you got him tied up, then you need to call the police and let the police come, because you have no excuse anymore to take the law into your own hands. And the danger of taking the law into your own hands is you might be making a mistake. You might overpunish because you're not unbiased. You're not impartial. You're partial. And your neighbors, they might they would be willing to they'd be willing to condone your use of self-defense in an emergency. But if you run around taking the law into your law into your own hands, and you run around acting like a vigilante and not turning the matter over to a neutral third party when you have the chance, then you sort of become a danger to everyone because you're kind of an outlaw. You're acting in a reckless manner. And I think that's going to tend to ostracize people, and be expensive because they might lose their insurance coverage. Their neighbors might not want to live near them, or they might even get punished by the family of the aggressor if they overpunished them. So there's lots of reasons not to take the law into your own hands when you don't have to.
Yeah. Well, where I'm from, if you like defend yourself and you in like a home invasion and you hurt the burglar, you could be in some spicy waters.
Right.
But yeah, no. So
And that's probably because of modern legislation in Australia, which has encroached upon the traditional defend your castle or the castle doctrine. You can defend your own home. In the U.S., that's still pretty strong. Like in Texas and other states, everyone sort of knows if someone is at your front door threatening you, you're better to shoot them and drag them inside your house and pretend like you killed them inside, and then no one's going to question it. It's that kind of common wisdom that goes around. But the idea is everyone sort of intuitively knows. And some states have extended that to carjackings. They'll say that if you're in your car and someone tries to carjack you, you can actually kill them if you have to. And I think that's reasonable. And then there's also things called stand your ground laws. Like if you're just minding your own business and someone wants to punch you or assault you, some jurisdictions might say you have an obligation to try to run away to minimize things. But some places say, no, you can stand your ground, even if that causes the situation to escalate to the point where you have to use lethal force to kill the guy, because he's the one asking for it. He's the one causing it. So it depends.
Yeah, it's always interesting. And I hope I'm never in that scenario where, well, I hope no one's in the scenario where they're victimized, but I don't know, especially where I'm from, it's just, it's just hard for, just to a lot of situations.
I mean, luckily you have your common law, so you still have I assume you still have a jury system for criminal trials. So I guess you could hope that your neighbors would vote not guilty. But who knows? The Australians are probably so statist and minded. They would do whatever the prosecutor says. It's against the law. He broke the law. And my guess is you're not able to tell the jurors of their right to vote on the justice of the law itself, which in the U.S. that's called the fully informed jury movement, which is a movement to try to get states to make it legal for the defense to tell the jury that they have the right to acquit based upon their view of the law. But the courts still don't allow that here either.
Right. Yeah, no, I remember this one guy in the city I'm in, and he had a home invader, and I know he decapitated him with a samurai sword. And he was like, and this was like years and years of legal troubles, but he eventually got off. Right. So, it's also the fear of just being, stuck with the bill of it all.
Yeah. And there's other things like some people, let's say you have your vacation home or a cabin in the woods. You're not there all the time, or even your home. And some people rig them with these traps. Like they'll put a shotgun by the sink pointing out the window with a string on it, where if anyone breaks in, the shotgun will go off and blow off, it'll kill the person trying to break into your house. Those things are generally illegal because they could be disproportionate. You follow me? Because there's no human there to monitor whether you need to do it. So you have to be careful about how you rig something to defend yourself as well. Unfortunately, I think those things should generally be presumptively legal. And then there's also cases of negligence, I'm sure in other countries too, where someone breaks into your house, like a criminal breaks into your business when no one's there, and he trips and he injures himself, and then he sues for negligence. And sometimes he wins because, there was a negligent hazard on the floor that he slipped and tripped on. Whereas I think in the old days, people would say, no, this guy doesn't get to sue the company he was victimizing.
Yeah. Yeah. Okay. So I kind of want to move on. So last time I was talking to Liquid Zulu. You've spoken to him before, have you?
I think so. Yeah.
Yeah. And so when I brought up Hoppe and his like Kantian influence, he described it as like kind of like cope, right? It's just like, oh, like the school that he came from, the Kantian school was like more realist school, and they view Kant as like this great Aristotelian, right? And he just said that's full of cope, coping. Yeah. And so you come from the objectivist school as well. So I'm just curious on what are your thoughts on like Kant and his influences on Hoppe?
I'm not a deep Kant. I'm not a Kant scholar at all. And I don't read German. I've read Kant and secondhand descriptions of Kant in English. But and I agree with Rand on her realism and on her objection to and her criticism of idealism and skepticism. I agree with all that. When she described Kant, I agreed with her criticism of Kant, but I'm not sure that Kant is who she was. I don't know if the person she was referring to was actually Kant himself. My understanding is Kant was somewhat of a confusing and brilliant but murky writer, and that's why there's so many schools of thought and interpretations of Kant. And from Hoppe and others, I kind of got the impression that in America, there grew up a skeptical interpretation of Kant, which is what Rand was sort of referring to. Whereas in Europe, the continent, there was more of a realistic interpretation of Kant. In any case, it appears to me that that's what influenced Mises and Hoppe, and they were not deeply influenced by Kant either, only in their terminology and in their basic understanding of describing the difference between contingent statements, statements that could be false, and things you have to find out from experiment and induction, and the causal method, the scientific method, causal laws, and then things we can know apodictically, as Mises would say, true, or they might say a priori laws, like the action axiom, and then even things Ayn Rand talks about, like fundamental axioms, she called it, like we can know that consciousness exists and things have an identity, and there's such a thing as consciousness, that kind of stuff. So everything I think Mises argues, the action axiom and the structure of human action, is just sort of common sense, but with a Kantian terminology. I've asked Hans himself personally a few times. Hoppe views his work on rights theory and his influence from Mises as Kantian only in the sense that he takes ideas where they make sense and he fits them into like this wall he's building, right? So there might be a brick here from there, a brick here from Spinoza, a brick here from Hume, a brick here from Kant, but he attaches them together with reason to make them make sense, and he doesn't care about their pedigree so much. And I think that's the right way to look at it. So I'm not trying to defend Kant. I don't really know what the real Kant actually meant, but I think that to the extent his concepts are interpreted in a realistic way as Mises, and see, Hoppe actually built on Mises' praxeology in his book Economic Science and the Austrian Method, primarily to extend it a little bit by showing that the action axiom of Mises is the reason we can actually be sure that our a priori concepts are realistically true, because it's action that is the bridge between the mind and the external world. It's a different way of looking at it from the way Ayn Rand looked at it, but it's a similar approach. They both recognize that there's an external real world and that we're aware of it. And they both believe that we can know some things for sure. Rand called them axioms. Mises and especially Hoppe and even Rothbard to some extent, even though Rothbard was more of an Aristotelian, also had this view. So I think they're all compatible with each other. It just means there's two types of knowledge. There's things we can know for sure that we don't have to test because they can never be disproven. Like you can never disprove the law of non-contradiction. You can never disprove the fact that there's a universe. You can never disprove the fact that there's consciousness. You can never disprove the fact that people act, and you can never disprove things that are implied by the fact of action, like that people have goals and purposes and they employ means to achieve ends, and that implies choice and opportunity cost and profit and loss and all these categories of action. So I don't know if it's copium or not, but I think it's a sensible way of making sense out of the world. And as long as it's compatible with realism, I don't see a problem.
Well, all right. Cool. And so, yeah, going back to Kant being a murky writer, I'm currently reading like this primer right now, and then I'm going to go into Critique of Pure Reason.
Mm-hmm.
And it said that he wrote Critique of Pure Reason in like 6 months. So, I think it's like understandable the murkiness and this reputation that he has, right?
Yeah.
Because of that time period. Like
one that I've read that I thought was pretty good was by Roger, if I recall, was by Roger Scruton. It's like 120-page book in the what used to be called the Past Masters series, but I think they renamed it. It's called something else now. But just look up Roger Scruton and Kant. There's about 100 or 200 or 300 or 400 books in that series. A lot of them are really good. They're all written by an expert on that particular character.
All right, cool. Thank you.
And if you like philosophy, another really good book that's one of my favorites is one that I never hear mentioned anymore because it's hard to find. It's by T.Z. Levine. It's called From Socrates to Sartre, The Philosophic Quest. It's a really good overview of philosophy for like the non-specialist.
All right, cool. Thank you.
I mean, for the non-specialist.
Yeah. Okay. Yeah. And so going back to like action and all of that stuff. I what I thought was really interesting that you were on Adam Heyman's show recently, and you were talking about how the Tesla Model Y is more likely to gain consciousness than a ChatGPT. Or something along those lines.
Oh, I don't remember saying that exactly. I think we were talking about Adam and I both were talking about how we both believe that for there to be some kind of new form of consciousness technology, artificial intelligence, you have to have a body, and that is actually implied by the theories of Peter Janik, a German philosopher that is not in English very much, but Hoppe has talked about him a lot. He's got something called Euclid's something. Anyway, I've got a couple posts about that. Maybe in my Adam Heyman show notes, I have some references there.
Okay.
Peter Janik. But anyway, the idea is that for a consciousness to develop, even if we overcome the technological problems, you have enough neurons and it's rich enough to potentially have an actual intelligence. You only develop intelligence by having, a desire to live and to function in the world. You have goals, and you have to do that. You have to have interaction with the world. You have to be able to manipulate it. You have to get inputs, but also outputs. You have to control things. You have to have a body, basically. So I don't remember talking about the car. We were talking about robots, I thought, but just a pure brain inside of a computer, I think could never develop consciousness. I mean, what do I know? But that's my sort of Omni Magazine Space Cadet grad school thinking. I just think you need a body to actually develop consciousness and sapience. So I think a robot with a very powerful brain or maybe a car, could theoretically develop consciousness. Although I'm still skeptical that, given current technology, as long as the brains are digital and they're not analog, I think it's going to be a longer time. Like if it was just an electronic analog brain that you could train it, it might somehow develop, and then you wouldn't be able to control it as much. If it's digital, I think it's a longer. Like I think my understanding is a lot of these so-called neural networks are not actually real neural networks. They're just a computer processor programmed to simulate a neural network. And even a real neural network wouldn't be analog; it would be digital. But I think we need to actually develop literally neural networks that have a vast number of neuronal connections on the order of the human brain, or maybe even larger if they're digital, if they're not analog.
Yeah. I don't know. I recently got into like these YouTube videos, and it's like evolution, like generators, right? And like they set up like a certain neural network, and then you add in like a chance of mutation, and then you add your I don't know, condition to kill off like how many odd people or things, and it's quite interesting how they evolve. Yeah. All right. So going to a libertarian issue that I don't know. I have some issue, I don't know, thinking about, because there's just so many, different things to consider. It's the open versus closed borders. And I don't know, at some time, like, I don't know, I used to be quite a firm closed borders libertarian, but then I don't know, I've just gotten more doubt with that position. So what are your exact thoughts on it?
I mean, ideally, I'm an anarcho-capitalist or an anarchist. So I think the state should be abolished, and in such a world, the concept of citizenship and even immigration would just evaporate. There would just be private property and rules related to that. In today's, I think Hoppe's analysis is roughly right. What Hoppe identified is that especially in today's world where there's no monarchy anymore and there's mostly democracies, and large, powerful democracies at that, which have led to welfare states and to all kinds of egalitarian rules like anti-discrimination law and welfare and voting rights and all this kind of stuff. In such a world, whatever the state's immigration policy is, and it will have a policy, like to the extent the state exists, it will have a policy one way or the other. Someone will be harmed by this, which is one reason we're against the state, because the state results in a situation where in a sense, we're all losers, and there's a war of all against all. We're all sharing for our piece of the pie, since the government forces us to fight for it, because they take from us and they only let us get back what we can fight back for, all this kind of stuff. So Hoppe's kind of paradigm is what he calls forced integration and forced exclusion, which means that if you have a mass immigration into a modern democratic welfare state, then this violates the rights of homegrown citizens, because the immigrants have the right to vote, they have the right to get welfare, they have the right to use the public roads to move in next to you, they have the right to work in your factories because you can't exclude them because of anti-discrimination law, all these kinds of things. So it's called forced integration. On the other hand, if you were to not have open borders, you're preventing some people from entering, and at least in a large number of those cases, it's someone that would be invited by a local resident who wants someone to come work for them or to live on their property, and they're not permitted to do that. So that's called forced exclusion. So that's the problem there. So both of these problems exist. Now, if let's take the United States. If the United States had open borders tomorrow, I'm afraid it would result in hundreds of millions of people, if not billions, just moving here. And you would lose the character of being American, and you'd maybe lose the country at a certain point. So you'd lose liberty. Just like if we had a one world government and we had egalitarian policies, then the top 10 rich countries would all become impoverished, because they would go from a GDP per person of or an income per person of $50,000-$70,000 per year to like 10. So that's why decentralization is always optimal and centralization is always bad, which is effectively what immigration is doing. It would basically extending the scope of this state to more people by having 1 billion people move here. Now they're covered. It'd be like making the world one state in a sense. On the other hand, as a libertarian, I simply detest and despise the federal government, of course, in the U.S., the central state, and I just can't side with the INS either, stopping people from coming. So I have like a dilemma, right? Now, my personal view is, like in the U.S. and probably many other countries, an obvious, not solution, but an obvious improvement would be if the U.S. were to simply say anyone can come if they're invited by an employer or by a property owner. As long as you have a legitimate invitation, you can come. That would result in, now it'd be better if that could come with limitations, like, and you can't get welfare and all that. But let's say whoever invites you has to be kind of responsible for you for some period of time. That would it would increase the number of immigration, because I think you could at least get 10, 20 million people a year in the U.S. if they were invited, but that's way more than we allow now. So it would expand the number of immigrants, and therefore it would reduce the amount of forced exclusion that we're doing right now. But it would also reduce the amount of forced integration, because the people that would come would be more productive. They would be less of them would be on welfare. So that would be a second best improvement, I think, would be to move to an invitation system. That's the only thing I can think of that would be an improvement in liberty for immigrants, citizens, and libertarians that live in the country.
Yeah. So in Australia, we have an election coming up, and our Libertarian Party has kind of put out like a similar Hoppe like invitee.
Oh, really? I didn't know that
thing. Yeah, it's not completely Hoppe. There's like, it's like an in between from like the current state to Hoppe. I forget the exact details, but it's quite interesting.
I mean, there are some countries that you need immigration, and you can see them doing better. I mean, the U.S. is pretty good at assimilating people. Probably Australia and some other countries, they need immigration, and they're good at assimilating it. Now, there are some other countries you could imagine, Liechtenstein or Switzerland or Japan. Now, although Japan might need immigration because of their plummeting birth rates, but
yeah.
But if you just open the doors in Japan or Switzerland or Liechtenstein, the countries might be you might no longer have Japan. It wouldn't be Japanese anymore after a certain point in time. And I don't think those costs are negligible. Everything's a difficult problem when you have collectivism and tribalism and statism all mixed in together.
Yeah, it is. Yeah. Well, I think it's good time to call it for a podcast. Thank you, Stephan Kinsella, for joining. This episode 4 of the Tyrants Den. Anything else you want to say?
No, I appreciate it, and good luck with your podcast. I look forward to adding it to my queue and hearing your other episodes. And anyone who's interested in these ideas, I wrote a book 2 years ago, which is a compilation and heavily updated and integrated compilation of my articles over the last 29 years on libertarian, on all this stuff, intellectual property, causation, rights theory, legal theory, like legislation and common law. So that's called Legal Foundations for a Free Society. It's free online on my website too, but you can buy a copy if you like to from Amazon. So that's stephankinsella.com.
Yeah, I'll have that in the description and your other social medias. So yeah, thanks for watching.
All right, thanks a lot.
All right.